Today, he wishes to express two issues to the court with regard to this, which is, one, he always wishes to be present at all hearings.
The record at this point, in spite of your comments, indicates that Mr. Sheley has a standing objection for not being present at that motion.
Well, we can rehear the motion right now, Judge.
That's my intention.
So let's do that. Judge, the motion that we argued previously, that I'm arguing again, essentially is this. By the time that we filed our motion, they had been unable to obtain this material, and that would have been greatly prejudiced our ability to attack this type of DNA evidence.
The previous order allowing the motion for continuance is vacated, and a new order entered in the presence of Mr. Sheley is such that motion to continue is allowed and delay is attributable to the defense over objection. You can put that in the growing list of your appellate issue column. I have been forwarded by Circuit Clerk Otten's document entitled Motion for an Amended Order is filed May 17th by Mr. Sheley, and he indicates in his caption he's filing this pro se. These types of matters are to be discussed with your attorney, and the filings will come from your attorney's office. The thing you raise is that the language that's included in the order is not what you recall specifically hearing in this court. And you filed your pro se motion to address that issue. You know what? If this is an issue of language as to what was said in court versus what was reduced to the written order ultimately filed, all that has to be done, Mr. Sheley, is if you get a hold of Mr. Karlin called the state, you might agree to what was actually said versus what was in the order. Without going through all this, without not advising your attorney, frankly, I don't understand your thinking on this. If it's an issue that needs to be addressed, it will be addressed. But the simple way of doing it is to begin with discussions between the parties, and that there might not be an argument about it. Well, now that I do know that Mr. Karlin knows about it, because as of this morning, he filed a motion for a transcript. The transcript is the indicia of the language itself to see whether it conforms to what was in the order or not. This is a very simple issue. There is no mechanism for the court reporter to be paid for daily transcript. I mean, if I allow this, arguably I could allow daily copy, which isn't going to happen. So your motion for a transcript of this hearing is denied.